It was, of course, a massive piece of music, a massive hit. You would have heard it again and again. Well, now there is a legal case about it. Shamsa, the DJ in Byblos, they're suing Master KG. They say that they're owed money for the composition of this. They're being represented by the intellectual property lawyer at Adams & Adams, Stephen Hollis. Stephen, good evening to you, and thank you for your time on The Pulse. On what basis are you challenging the ownership of this song?
Good evening, and good evening to the listeners. And so what we have when we have a musical work is usually a collaborative work of multiple creative contributors. So you typically have somebody who composes the composition, you've got somebody who writes the lyrics, and you've got a producer who does the mixing and mastering and the arrangements, and ultimately produces the master recording, which can then be commercially released and commercialized. Now, in this case, there wasn't appropriate rights clearances from all of the creative contributors. So the song was, in fact, on the information before us, composed by the producer Shamsa the DJ, who was invited to Master KG's studio around August of 2019 to help Master KG touch up a few beats and arrangements that he prepared himself with the view of collaborating with Nontlebo and for the two of them to release the song commercially. But what happened ultimately is that Shamsa, while at the studio, in his own and private and personal time, he composed a song of his own, which ultimately was the melody, the composition, the beats and the arrangement for the Jerusalema song. But he kept that apart separately. That was his own creation. When Nontlebo arrived at the studio the following day and listened to the 2 or 3 tracks that KG prepared and that Shamsa, the DJ, touched up for him as a producer, she didn't like any of those versions. Shamsa then played her his song that he created separately, his melody and the beats, and she loved that. It was the sound that she was looking for, and the two of them then collaborated in the studio. And I understand that Master KG wasn't even in the room for most of the time, maybe even the full time that the song was produced. So the two of them worked closely together. Shamsa the DJ and Nontlebo. Nontlebo wrote the lyrics, and she, of course, performed as the performer on the song. The sound recording, the master recording, was produced by Shamsa. Shamsa was then told by KG that they will discuss rights clearances later on. He returned to his home in Limpopo, and he was very surprised when the song was commercially released and he wasn't contacted at all. The song also contained a sample of another artist's sound recording of Byblos. And that sample is of Byblos pronouncing in his own voice, Aish. And that Aish was turned into a beat, a very unique and distinctive beat. And his voice can be heard 114 times on the track. And while this is the case, Byblos was never approached for a rights clearance, or he didn't even receive a phone call or any acknowledgement from Master KG and his record label Open Mic. So the issue is that these rights were never cleared before, and their rights were never transferred. You can only transfer copyright in writing. So these artists are still vested with rights of copyright. They've been stonewalled by Master KG and his record company. And this has now resulted to where we are today, with legal proceedings instituted so that these claims, which we find to be credible claims, can be considered and adjudicated in a court.
Stephen, can you prove that Master KG wasn't in the studio? And I mean, allied to that, if it was created in his studio, does ownership vest in the fact it would have been recorded on his equipment? I imagine it was stored on a computer on his property.
Well, you can, if you commission a producer and you pay that producer to come and work in your studio and produce a song, then the commissioner can then be vested with rights of copyright. But the difference here is that Shamsa was never paid a cent. So the commissioning clause in the Copyright Act doesn't come into play. Also, Chamza produced the work not under any direction or control of anyone else. He did it in his private time, and whether he created it on what equipment he created it, he wasn't commissioned to create that song, and there was no contract. There was certainly no employment agreement, so he remains vested with the rights of copyright. There are persons who were in the room, in the studio at the time, who can testify to the fact that Master KG wasn't in the room for the majority of the time that the song was produced, and that was a close collaboration between Chamza and Nomcebo, ultimately, who worked together to create that song. More on that to follow once we get closer to the court matter.
Stephen, how much money are you asking for? And this gets to the heart of how compositions that are collaborations in a music streaming era, not the physical era, no one buys CDs or records anymore. How much money do you think you'd get? I mean, how much money is this worth for your clients?
Well, this matter is not just about money. It really is about recognizing the creative contributions made to a song that has become a global phenomenon, as we know. Just being involved as a producer of a successful song can open other business opportunities for the producer. So it's always in a producer's interest to be recognized as being the producer of a song, and also the person who composed the melody. So that's number one, is the recognition of their creative contributions made. They've also, as copyright owners, got moral rights to be recognized as such. And the second thing is the equitable remuneration. So we have to consider, the just and equitable remuneration for the talent and the skill and the labors of these artists, who, without which the song would never have seen the light of day and would never have had an opportunity to inspire global audiences. So it's about recognition, it's about fair compensation, and in this case, it will also be about damages suffered for really flagrant and ongoing infringement of their rights of copyright, not only by Master KG and Open Mic, but also the distributors of the song. Africori was joined in the proceedings as the distributor, and Africori internationally, Warner Music Group has been commercializing the song. They own a majority share in Africori. So it's any party who's commercializing the song without the permission or license of all of the creative contributors and copyright owners.
I mean, I can't think of a South African case like this. The international one that comes to mind is Blurred Lines, Marvin Gaye's family. It was Pharrell Williams. It was Robin Thicke. The family won against that. I think that was $5 million. Are there cases in South Africa like this? I can't recall one.
So in South Africa, our artists generally lack the funding to see a matter through to final determination. And because in South Africa we don't have what they have in the States, statutory and punitive damages, it's not that easy for an artist to secure legal representation for the years that it might take to see litigation through on a contingency basis, with a hope that once the statutory and punitive damages are awarded, there's sufficient monies to also pay your legal fees. Adams & Adams is representing these clients on a pro bono basis because we've recognized that there's an unjust situation that needs to be remedied. It's a matter of ethics as well as business.
Stephen Hollis, thank you very much indeed. Really appreciate it. Intellectual property lawyer at Adams & Adams. Let's have a look now at your headlines.